Good evening, ladies and gents. Cyril again. Last tutorial of Contract A for this term. Let's keep on going. This evening is about privity. Okay. So the doctrine of privity is still quite alive. So, Jason, you poor guy, can you just give me a feel of what privity is all about? What is privity?
So basically, when you enter into a contract with someone and there's a third party, they're under no obligation of that contract. Is that correct?
Yeah. And because there's no consideration. See, the word privity means you're not, a part of the contract. If it's you and I, you have obligations and you have rights, and I have the vice versa ones. But if we do it for a third party, that's where we get the difficulty. Now, and you can imagine the whole idea is that a third party, well, they've given no consideration. And indeed, we can't force another party to do obligations against their will. That makes a lot of sense. But there's a bit of injustice. Jason, give us a bit of a feel. Do you have any recollection of some of the injustices which may occur?
Are you referring to the cases that...
Yeah, because, see, what's happened is he's given us a feel of the injustices by providing us with 3 cases.
Okay, so that Dunlop versus Selfridge case.
Yep.
He tried to sue Selfridge, which was a contract between, I can't remember the name of the other party, and Dunlop wasn't able to do so because they weren't in a contract with that particular party.
Lovely. Well done. Let's have a quick look at that. You're right. I just used my words.
Yep.
Dunlop went into a contract with Dew, and Dunlop said, look, you can't sell under a certain price. Dew said, no problems. And then Dew sold to Selfridge, and Selfridge did what it wanted. Indeed, it sold under that price. And Dunlop sued Selfridge. And because there is no link, there's no consideration, they're not privy to the contract, Dunlop's case failed. Okay. Now, the next case we had in the series, there's 3 cases, Coutts and Baggett's executors. Can you remember anything to do with that? The quarry case?
Yes, so the owner of the quarry passed away.
Yep.
Before he passed away, he was he was giving profits of the quarry to his wife.
Yeah.
And then after he passed away, because she wasn't party to the contract, they no longer gave her profits.
Yeah. Change it. Let's look at it. It's only slightly different. You're pretty close to it. Mr. Cools was the owner of land, and he didn't want to do the quarrying himself. Someone else wanted to do the quarrying, and they paid him rent. Just like you and I, if we rent someone else's house, we have to pay them rent. And he said, Mr. Cools said, oh, don't pay me, pay my wife and I. And after he died, and the tenant being, we don't know the name of the tenant said a very valid question, who do I pay? Do I pay Mr. and Mrs., keeping in mind that Mr. is dead, or who do we do? And the executor is the party after you die who takes care of your affairs. The executor wasn't quite sure, and they went to the court. And the court said, what did the court say?
That they didn't have a contract with Mrs. Cools? Cools?
Yep. Cools, yeah.
So it went to the estate, didn't it?
Yeah. By the way, good evening, Darryl. Nice to see you back.
Yep. How you going? I don't have to work tonight.
Sorry?
Don't have to work tonight. I did that last night.
Good on you, man. Now, we just started 5 minutes ago. We're just going into the injustices. We've done Dunlop and Selfridge, and we're just looking at Cools and Baggett's. Basically what happened, that Mrs. Cools, who was a recipient of the rent, but she was not a, good evening, Jade, was a, she gave no consideration. She wasn't able to get the money. And that was seen to be a great injustice. And we've got, now the High Court looked at this years later on in Trident and McNeese. Now, I've got, Darryl, would you like to have a go at Trident and McNeese?
That was in relation to the Bluestone Quarry.
No,
That's with the insurance company in the Bluestone Quarry, or the Blue Circle.
Blue Circle, that's right.
Yeah, Blue Circle. McNeese were the contractors that came in afterwards. There was an injury, and then because the insurance was with Blue Circle, it wasn't with the contractors specifically. So therefore, they were deemed as not to be covered in that regard.
Yeah, it's just following on that line of cases of Dunlop and Selfridge, Cools, and Trident falls on. Now, someone else, Jade, are you able to talk?
Excuse, before we get too much further on that, I was only thinking about that one today. Is that if you go onto a work site now as a subcontractor, of course you need your own insurance and public liability, everything else.
Yeah.
But if you have an overreaching insurance, say you're working for a building company, I'm an electrician, I go in, fall off a ladder, break a leg. I know that I'm public insured. However, is that still the case in that regard where it's only your insurance doing it? Because that building site should be insured as well.
Yeah, well, you would claim on both policies, and probably what happened is that the employee, Mr. we don't know his name, he asked for McNeese to pay him compensation, and McNeese said, "Well, we'll claim from Blue Circle," and Blue Circle said, "We'll claim from Trident." And Trident, like a good old-fashioned insurance company, said, "No way, Jose, we're not going to do it because of lack of privity." Now, answering your question, nowadays a contractor would have to have their own insurance to have a go at his own insurance. Look, a contractor would rather have a go at someone else's insurance because you don't have that first amount of money which is deducted, the excess deducted. But if not, you'd fall back on your own. But it could be a situation where the injured person was an employee, and employees you don't expect to have their own insurance. So they're the three cases. So those of you who have joined us, we're looking at privity tonight. We've looked at the rule, the general common law rule, and then we've looked at the injustices, which are brought out by three cases, Dunlop's, Cools, and Trident's cases. Now, this is all very unsatisfactory. The rule, the privity rule has a good feel to it, because why should a person who has not given consideration be able to enforce a contract? And in reverse, why should someone who's not part of a contract be obliged to do something? So the theory is good, but like a lot of this stuff, there are injustices, and therefore exceptions have grown up. So the first one, which Anthony spoke about both in his notes and in the lecture, was about the statutory exception. So Jade, are you able to speak? I think she's probably just here. Jason, give it a go. The statutory exception.
For Queensland?
Yeah. Remember, it's only for Queensland.
Only for Queensland. Okay, so basically in Queensland, we establish who the parties are. Once we work out who the beneficiary is, the contract between party A and B can be accepted by the beneficiary, but it won't come into effect until it has been accepted by the beneficiary by contact or notice. Good
stuff. And really, it is as simple as that. And we'll have a look at this as we go through this. Now, regrettably, it's only in the state of Queensland. Now, that's enough to drive anyone insane. And later on, when you practice law, either directly or indirectly, directly as a solicitor, indirectly where you have a law degree and you're working in an office and you're giving some sort of legal advice and assisting, these things drive you totally insane. Now, can you imagine until the Australian consumer law came along, it was all over the joint. It really, really was difficult. It's still difficult enough as it is. And it makes it even more difficult that one state has it. So we've got those things there. Now, so that is a situation in Queensland only. Now, what about the rest of Australia? We have judge-made law, okay? Both common law and equity. So, in his notes, Anthony said that we're going to talk about estoppel, but that'll be next semester. Okay, so that's an equitable remedy. And just while we're there, I was talking to a QC a while ago, Queen's Counsel, which is a senior barrister. We were talking about remedies. Now, remedies, of course, will be next semester. But he said to me that if there's an injustice, you don't have to look too far. You will find a remedy somewhere. Okay? The English law is all full about remedies. What are you reading, Jason? Is it good? I'm getting hungry myself.
Delicious.
What is it?
It's mac and cheese. Nothing
Sounds
exciting.
good. So the first one, well, Jason's tucking away into his dinner, so I'm sorry, Daryl, you're the one, and Jay's just listening in the background, so she can't, so it's on to you. Now, tell me about the first of the exceptions. This is the judge-made one, agency.
The agency, yeah, I can act on somebody else's behalf. I'll be his agent, and then what I deal with, what I sign and agree to, I'm acting on behalf of the actual person.
Yeah. Now,
so it's basically, it could be for a company, it could be for anything really. It may be that somebody's intellectually impaired.
Exactly. So let's say that you're absolutely right. I'll just use my words. An agent, when you finally do agents in your degree later on, all an agent is an extension of yourself. I'm not good at selling homes. I'm not good at doing my tax. I'm not good at other things. And another person in the community is not good at doing their legal work. So they get someone to do it for them, and they give them the authority to act as if it was them. Okay? So, and that's what it is. And so an agency situation is you get A and B are in the contract for and on behalf of C, but C and B are the same person. Well, they're not the same flesh and blood person, but you can imagine legally they are the same person. Okay? And so therefore it's a little bit unfair to have the doctrine of privity be active there, because it's unjust, because parties B and C are the same legal entities, the same legal party, or the same rights.
Would they
very well?
Would they, depending on the type of arrangement with an agency, they would be limited in their rights?
You have a number of different agencies. You can have a limited one where I'm living here in Victoria and you're living in Queensland, and I get you just to do my work in Queensland, or I just get you to do my tax work but not my legal work. So yes, you can limit it. Or if you have another one where you will only deal with my hospital issues and someone else will deal with my financial issues, that sort of stuff. So to answer your question, yes, you're the one who's giving the authority, and you can tailor it to how much you want to have given. Of course, you don't want to have an emergency and then the way you've written the document is too narrow and therefore I can't act for you. That sort of stuff. Yeah?
I was thinking about along the lines of power of attorney. Is that what the term is, where someone takes over?
Yeah. Now, what happens, depending on your jurisdiction, they have a number of different ones, and they've changed them not so long ago here in Victoria. You have an enduring one, and when you have a limited one. They may have changed, I just can't remember. And so I might give you, Darryl, I might just give you, say, for the next 4 weeks whilst I'm overseas. Or I feel dementia coming on, and I think, look, I've just about gone. I want you from now onwards forevermore to represent me. Okay? So it can be for a limited period of time. It can be for a ad infinitum. It can be, the width can be wide or narrow. Okay?
Yeah. So but that's not part of the agency side, is it?
Well, it is, because an agent is the person who represents you.
Yeah. Okay.
It's a type of agent.
Yeah.
How you were added in. Okay, so Jason, I just see that you flipped back on the screen again. So it's for that we're going to get you now. We're going to get you to do trusts. Can you tell us about the exception in relation to trusts?
So basically, it is pretty similar to the agency thing, where you give a particular party. How do you say it? a particular party your permission to speak on your behalf.
Yeah.
But I don't actually see. So who can be a trust, but who can't? Who can be a trust and who can be an agent?
Let me explain it to you. It's a concept familiar only to English law. Other legal systems doesn't have it. And I can't remember the exact background, but it was something like when the Knights went to the Crusades, they left everything behind. So Jason, I'm going to the Crusades now, and you're, for whatever reason, you might be a relative or whatever, I leave all my assets, including my family, in your name. And you hold it on trust for me. In other words, it's in your name, but the whole purpose is it's to take care of me. Likewise, my wife may have made a lot of money, and she gives it to someone to hold on trust to take care of the children. That's that sort of things. Okay, so you can see there is a similarity with agency, just as you mentioned. So that's good. And the similarity is that it's a little bit unfair to you have parties A and B are there to the contract. Party C is the beneficiary. It's a little bit unfortunate to get rid of the beneficiary, not allow them anything, if the person B was a trustee, which is really basically an extension of them. What they're doing is they're holding it on someone else's behalf. So you have person A and going into the contract. Person B is the other part of the contract, and they're only doing it for someone else. So it's very similar to agency. It's greatly unjust if the beneficiary misses out because of the privity rule. Did I explain that properly, or you want it again?
Yeah.
No,
So you go, Daryl.
Yeah, no, it's is it relation with the trust on companies as well, or is that looking at it in a completely different area?
Yeah. See, what happens is that this goes into equity and trusts, which we'll discuss later on. But what happens is that the trustee is liable for any loss of money and things like that. So it's really dangerous to be a trustee. And so what everyone does is they want limited liability. So with corporations, you have limited liability. So therefore, the trustee is no longer an individual, it's a corporation. So when I advise people and they're just going to hold money, there's very little risk in that. But if you're going to run a business as a trustee where people can get sick from the food and stuff like that, no, you just would not do that unless it's in a corporation and you have limited liability.
So that would be the main difference between an agent and a trust, wouldn't it?
Yeah, an agent is where the two people, let's say you and I, Jason, I'm sick and a lot of stuff has to be done. So I give you the authority to bind me. You could even be my tax agent or my lawyer. You are just an extension of me. So legally, you and I are the same. While we're different flesh and blood people, but you see, it's slightly different with a trust, where I'm the beneficiary, you're the trustee. You hold the assets for and on my behalf, and you have to follow what's in the deed as to what needs to be done. So there's a similarity, but it is different.
Yeah, I'm following you. Yeah, that makes sense.
And look, I wrote the paper, and it's I can't remember anything. I think, look, these things are quite complicated, and if there's anything, it would be on the statutory part. Okay, if there's anything on the statutory, but you really should know this sort of stuff. I had my son today had a problem with he's a movie director and some of his equipment, and instead of going to the legislation, I just opened up last week's Anthony's lecture from last week, and I think it was section 54 and 55, and I just said to him, it's got 54 was 55 is fit for purpose, and the other one's got to fit in with what they promised you it's got to be, and just send it off to them. So these things are actually very helpful. So that's the trust situation. So let's get back to you, Daryl. Tell us about the other one, the unjust enrichment. Just before I go, you all have done or you are doing legal process? Have you done, Daryl, you done legal process?
I did it a couple of years ago, I think.
Okay.
Yeah.
What about, okay. So the whole idea is in the law, coming back from, since the Norman Conquest in 1066, from there onwards, we've had the common law common to the land. Now, it didn't take long to become very, very inflexible. And in fact, it was so inflexible, a lot of injustice occurred. Part of the injustice is that it can only give you the remedy of damages, which is dollar amounts. And some people don't want dollar amounts. If you've stolen mail or written off for my antique, I don't want dollar. I want that antique or that piece of land. So on top of that came the Court of Chancery of Good Conscience. And that's what was called equity now. So we have common law, and which is judge-made, and judge-made equity. And so that overcomes, and there's a hierarchy there. The equity usually only comes in to assist where common law hasn't done a good job. Now, on top of that again, what do we have?
Equity.
Yeah, we've got equity there. We've got legislation on top.
Legislation, yeah.
Legislation, okay? And that's where the Parliament, either state or territory on one side, or the Commonwealth makes legislation. And that sits on top of both of it. Because, look, morals change, people change, ideas change. Some of the laws haven't changed. For example, the promise theory we spoke about. You have large corporations and small individuals. Well, they can do whatever they want. Well, that's not acceptable in this day and age. And so legislation has come in, part of which we spoke about last week. It was the unfair contract terms and the small business unfair contract terms. So that's some of the legislation. It's coming. So therefore, as I've said to you for a number of weeks now, as lawyers and later on, you need to know the hierarchy, the common law, the equity, and the statute. Now, the statute, keep in mind, is broken up into two parts. That's the state and territory on one side and the Commonwealth on the other side. And when you study constitutional law, you'll find out which takes priority, which in essence, normally the Commonwealth takes priority, but there are some rules on that. Okay, so let's get back to work here. But it's important we discuss equity because you have exceptions here. You have equitable and common law exceptions, and you have statutory exceptions. Okay. Now, did we talk about unjust enrichment? No.
No, not yet.
No. So Darryl, have a go at unjust enrichment. Yeah,
it's when somebody's being enriched over the bad luck of somebody else, to put it plainly. It's the contract is unfair. It's an inequitable solution or result coming from it.
Yeah, if I think he had an example in the book or something like that, that someone was supposed to do something, the person in the middle, for someone else, the person in the middle became incapacitated, and therefore the person who wanted to take action couldn't do that because they're outside the contract, because there's no consideration, and therefore the tradie didn't have to do the work. Now, in anyone's mind, that's unjust enrichment. They've kept the cash. Now, in Cool's and Baggett's case, was there unjust enrichment there?
To be honest, I don't recollect that case straight off the top of my head.
That's the Quarry case.
Oh, okay. Yes, with the lady, the fella died. Yeah.
Now, Mr. Cools owned the land. And the tenant paid him money, and Mr. Cools said, "I'll give it to my wife as well." And now I don't see any unjust enrichment there, because the Quarry company, what do? They were still paying the royalties, just where it was going. They just, absolutely, 100%. So wonderful.
State instead of to her personally.
Yeah. So therefore, unjust enrichment is not an issue in that particular case. Okay. You could say that in Trident, unjust enrichment is an issue there, because the insurance company took the premiums, but didn't give everything. And that's what Anthony was saying. He said the case is a bloody mess, and he tended to favour the unjust enrichment. But regrettably, we all look towards high court cases, but there was the decision. If you look in the book there, at a quick summary, you'll see that there's a number of different ones. They all said it was injustice, but as to their way of overcoming it, one said it was a trust, one said there was an agency, I think, and the other one's unjust enrichment. The whole
4 different methods. I
yeah.
think there's 4 different results on that one.
Well, it helps absolutely nobody.
Mm.
And so therefore, Daryl, you can help the whole world, or at least Australia, by going out and doing something and being sued in the High Court and clarify the whole issue of privity, okay?
Right, I'll be on it next week. After the paper. Yeah, after your paper, okay? Not a problem. I'll crowdfund it. How's that?
Yeah, oh, it's very kind of you. No? So therefore, now what we've done is we've looked at some of the equitable issues there. Let's now go and have a look at the common law one of collateral contract. Anyone like to have a go?
Well, to the collateral contracts are a sort of a secondary contract off the main one.
Yeah.
So you can be, if it goes along the lines that you can be involved in one contract, but you're not involved in the other. So you could use the privity on one side of it, but not the other.
Yeah.
So I think the landscaper is the example in this regard.
Go on.
Or was it building a house? But they build a house, A and B agrees to build a house, have the contract, as long as C does landscaping work for them.
Yep, it's good.
C is not involved in the housing side of it, but they are involved in the landscaping side with the collateral contract.
And you see what happens is ordinarily there would be privity for the beneficiary. Forget the statutory part and forget the other common law or the equitable parts. You know, they wouldn't be able to claim. But again, there's injustice. And what the law has looked at, and as Anthony says, it is a bit contrived that there is the two contracts are basically interwoven, because one is the price paid for the other contract, and therefore you should be able to go ahead with that. And that's the collateral contract issue there. Okay? So I wasn't really going to go much more on that because it was a rather short chapter, and that was the law behind it. I just made a note for myself here. The doctrine of privity still exists in Australia. We still need to show that we have given consideration under the contract, or we are an intended beneficiary under the contract. That sort of thing. You know? So if you're outside of Queensland, you cannot use that statute. It's in Queensland only, and it's just regrettable that it hasn't gone beyond Queensland. Okay? And so in this, so quickly, can Daryl just give me a quick rule of privity, just the rule, and just quickly what the exceptions are and how we overcome it.
On the Queensland rule?
No, the general rule, the common law rule of
privity. It's that a third person is not a party to the contract, so therefore they can't get remedies from it.
Perfect. Okay. What injustice can occur out of that?
Well, we've just gone through them.
No, not the exceptions, but the injustice. The injustice is that they might miss out.
Yeah, they could be. It'll be something that they like that Bueller case there, where they don't receive the money; it goes elsewhere.
Exactly. So in other words, it's not fair because they should have a right, but they don't have a right because of a technicality.
Mm.
And the law doesn't like that, and so it's brought the exceptions in. It's got the statutory exception, and it's got the judge-made exception, which is the common law and equitable rights. Okay, and we've gone through those. So I always like putting them in flowcharts because my brain works better. So if you just remember, just the skeleton. What I've just done in the last 30 seconds is the skeleton. Just make sure that skeleton works. You got that in your mind. Okay. Any other questions before we go to our tutorial question?
No, I actually quite enjoyed privity. I thought it was pretty good.
Can you remind me later on? I want to go through your 36-hour test, drop a few hints, and just give you some hints as to what the content will be and hints as to how you should attend to it. Okay, so just remind me after that. Okay, now let's have a look at our tutorial question here. We've got 3 people here. We've got Marg, she's the owner of the flat. Alex, she's the boyfriend, was the boyfriend, and Steve. Now I'm going to find the page. Here we go. Okay. Now, the facts were that Steve wanted to do a good deed, and he goes to, Alex wants to do a good deed, and he goes to Steve, and they enter into a contract. And Steve's the ex-boyfriend. Alex is the ex-boyfriend. Steve is the kitchen designer and installer, right? And there's a simple contract there. Now, whilst it doesn't say there, when you look at the facts and you read between the lines and you sort of look at what's there, it becomes pretty clear that Alex has actually paid for the work, and Alex has signed a document stating that he's satisfied with the work. They're really careful with that. You know, I was in a case not so long ago about that, but be careful with that. Now, just while we're on that, visually it looks okay. Well, you know, how's he supposed to know that the stuff underneath hasn't been done properly? Okay, so Mark comes back really annoyed, doesn't like the work. That's the first thing which he thinks about is kicks him out. And what does he do? Tail between his legs, he runs off to Western Australia, works in the mines. Okay, what I think Anthony means about that is that he's non-contactable. He's out of the picture. Now, so Mark puts up with the kitchen, and then she finds out it's not fit for purpose, and she wants to have a go sue Steve, the kitchen designer and installer. Now, we are only to answer from the privity viewpoint. So therefore, Steve, the tradie, he is relying on the doctrine of privity and that document of acceptance. Okay. Now, does this lead to injustice?
This will be a massive injustice, this one.
Justice. Okay. So, does one of the exceptions to the common law rule apply? Well, give me at least the headings of the exceptions. One heading is
unjust enrichment.
Yeah, that's right. Or I layer up. One level is legislation, and the other layer is judge-made, isn't it?
Yeah, common law.
That's why I like my flow charts, because it's easy for my brain, and you should do something similar to. And what you do, you go through them one by one. So let's assume now it's in Queensland. What does Section 55 of the Property Law Act Queensland state here?
That she's entitled to sue the guy that fit out the kitchen. I can't remember his name.
Okay. Now you got to point three things out.
But she didn't know about it. She didn't know nor accepted the work to be done. So I had a look at that one. The way I read that one with Queensland is she had no idea. So she's not a beneficiary. She's not a party to the contract in any way. Yeah.
So let's go through them one by one. And these are the things we have to drag out. The first thing you have to work out, who is the promisor, the promisee, and the beneficiary. Basically, really it's A, B, and C. The promisor and promisee, they're the two guys. They've gone into a contract, and she's the beneficiary. So we know that. That's pretty straightforward. The next one is there a contract between the promisor and the promisee for the beneficiary of the benefit of the beneficiary? Well, that's a question whether one was done in the first place. But ultimately, that's what it is. Now, the most important part is once the promise is made, the beneficiary has the choice of whether to accept or reject. Now, if she accepts, then the promisor, basically the tradie, he is bound, and if she, but she's also bound by the obligations. Not only does she get the rights, but she gets the obligations. If she rejects it, well, therefore she's free of the contract altogether. So what Daryl is saying is that does the legislation apply or not? That's what you're saying. And we have to, it's a strict interpretation of this legislation. From what I don't have experience with this because it's not my jurisdiction, but from what Anthony was saying in the lecture, he was giving quite a detailed analysis of this, and he was saying that you need to make them aware of it, and then they have the choice to accept or reject it.
she didn't actually
Either actions, yeah.
and you know, with that Queensland rule, if you can accept by conduct, so she's obviously used the kitchen because it states in the facts here that hang on, let me just find it. Margaret soon discovered that she had done a poor job. The appliances did not work correctly and the wet areas were not waterproof. So I just assumed on that basis that she has began to use the kitchen.
Yeah.
So she sort of done some sort of conduct to accept it.
Yeah. Well, that's a good point. See, and these are, look, let me just say this to you. Irrespective of your right or wrong, the main thing is you're thinking legally and you're thinking in the alternative. And that's really good stuff. I like that. Because a lot of times what you're doing now, instead of talking to a tutor, you're talking to a judge. You may not know. So you argue in the alternative and you put it forward. So it's good thinking. My personal opinion is that she can accept it, and therefore she has the right to have a go at him. Now, we were Anthony in the lecture was talking about Dunlop's case. Remember, you had Dunlop, Dew, and Selfridge. Now, if Dunlop wanted to have a go at Selfridge, they can accept or reject, assuming it's Queensland law. Well, of course they would reject, and therefore they wouldn't be brought into the contract because they don't want to be bound by the obligations. Okay? If the beneficiary on the end, being party C, A and B in the contract, C is outside the contract. If the beneficiary agrees, as we said before, they get the rights of the contract and they get the obligations of the contract. The case of Dunlop and Selfridge is all about obligations. Selfridge didn't want to be bound by those obligations, so it just needs to say no. How are we going with that? It's in the lecture anyway. With Cools, Mrs. Cools would accept it because then she becomes basically almost like a party to the contract because she's a beneficiary. So she would accept that. And in Trident, well, we have all sorts of different ways of doing it, but what I made a note here. Here what you would say is that the worker would accept because he would get the benefits. But Anthony said also he would get the detriments, and the detriments would be he'd have to follow OH&S rules and things like that. So I think from the statutory alternative, if it was in Queensland, I think Marg, she would be able to have a go at Steve. Now, arguing in the alternative, what happens if for some reason she doesn't get the benefit of Section 55, therefore she has to go back to judge-made law, and if we were, which is the same as being outside of Queensland, okay? So the same thing. So let's have a look now at the judge-made law. So estoppel, well, that's not an issue here because we'll be discussing it in the next term. But what estoppel is all about is reliance on someone else, but we'll talk about that later. Agency, let's look at the agent situation here. Now, who would like to have a go at that?
Well, Alex was clearly not an agent of, what was the name?
The girl, what's her name? Mark.
Mark. Yeah, Mark wasn't an agent of Alex. He didn't have authority to put this kitchen in. He did it out of goodness of his heart.
Yeah, exactly.
So to speak.
Yeah, no, exactly.
Like Western Australia.
Yeah. Now, he hasn't disclosed the agency, nor did she ever approve of it. And so if you're answering the question, you'd say, look, agency probably isn't one of the exceptions that you'd rely on. Trust, what about that? What about Jason?
Well, I don't think she's really addressed him as a trustee, to be honest.
Exactly.
She put her house in his possession, but only to look after it. So I wouldn't say that he's a trustee.
I like it. Well done. It's good. So therefore, both the first two, agency and trust, both of those situations aren't of assistance. Now the next one, unjust enrichment. Go back to you again, Daryl.
I'll just have a look if I can fit unjust enrichment in it, but I don't think she's being enriched by a dodgy kitchen.
What about him?
The tradie's been enriched by putting in a dodgy kitchen.
He has.
The tradie would be enriched, but that'll be about the only one in the common law to be able to rely on.
Yeah. Just from a terminology viewpoint, common law is usually just to deal with contracts, and you've got the where it's unfair, that's where equity steps in. Unjust enrichment is an equitable remedy. Okay.
Equitable, right.
You'd hardly lose anything if you said that, but it's just the correct way of looking.
Yeah.
It's the correct law. Now, unjust enrichment would be a possibility here because the tradie has done the work, he's been paid for it, it's subsequently found out to be not fit for purpose, and as we've been told, we're not allowed to look at the ACL stuff. So he relies on the privity doctrine, and we now have to see whether there is some sort of exemption to that. And there's quite a possibility of unjust enrichment because he's being unjustly enriched unfairly, because the whole doctrine of the law of equity is to become equitable. Okay? And the last one is collateral contract. Jason, what do you reckon?
Well, I don't actually see there being a second contract here either, so I don't think this applies at all. So
I agree too.
She really didn't have any knowledge of it, so how could she have made a contract in any way? Yeah.
Now that's good. I like that. All right. Now what I'd like to do, unless there's anything else, I'd like to just go through your final paper. Anything else you'd like to talk about before we do that?
I do have one quick question.
Yep.
No one can submit their tutorial participation assignments. It keeps saying that it's unavailable at the moment to students.
I will make a note, and I will ring up Kazak in the morning. I've had a few. Some of the computer stuff is difficult, So that's the assignment 4, isn't it?
Whatever the tutorial participation.
Yeah, exactly. Leave it to me. First thing tomorrow, they open at 8:30 Melbourne time. I'll give them a ring then and get that sorted out. Okay. Now, the final paper, my recollection, you got 36 hours. Okay. Now I wrote it last week, and I got it back. They just did a couple of typos and things I fixed up, and I got it in front of me at the moment here. So I'm not going to give much information. I'll give some of this information to the others, so they need to have some idea. But I'll give you guys more because the people who actually come to these tutorials, you need a benefit for coming along, putting it with me. Okay, 40 marks. The first part will be worth 10%, and you'll get 10 really minor questions at 1% each.
Is that like in a problem format?
You just a sentence or two.
Yeah.
It's not on this question, but does the ACL look at major breach and minor breach?
Yes.
Yeah? It's like that, really straightforward and simple. Don't write too much on it. You might have something like what is privity? You might have something like that. Okay.
All right.
Don't overwrite, because what happens is that you go on and on and on. Just answer it and off to the next one. And put it this way: if I see it and it's basically there, you get the 1%. If you spend an hour writing on it, what are you going to get? 1%.
1%.
Okay. So you may as well be sensible and go on to the other question. So that's part A. and that's all about that's all about short answer questions, right? And part B is there are 5 questions at 6 marks each. 5 questions at 6 marks each. Let me get my calculator. 5 times 6 is 30. There's your 30%. Plus your 10% makes you 40%. Okay. Now, you should be able to answer in a couple of paragraphs. Okay. Do not overdo it. Don't rewrite the question. Don't dawdle. Don't beat around the bush. Just get right to the point. They're really practical things. If you've been listening to the tutorials this year, this term, it's sort of issues we've been talking about, practical stuff that you can imagine if you're out there in the real world. Okay. Now, I went through the topics. They come from the whole of the term, but I'd have a look at capacity, intention, agreement, express terms and implied terms. Capacity, intention, agreement, express terms and implied terms. If you ignore all the other chapters, you do at your peril, because there'll be issues from there. Okay? There'll be issues from there, but there will be, it's good to look at those areas. All right, that's the content. Now, how should you prepare? The first thing I'd suggest to you is to go to Anthony's lecture, lecture 12, this week's lecture, and have a look at the last 5 minutes. And in the last 5 minutes, he gives his thoughts on the matter. Actually, very good. Things like don't waste your time. You've been given a certain amount of time. Don't do it all in 2 hours and then just run off to Netflix. Spend your time, review it, and for heaven's sake, submit it an hour or so or 2 hours before the deadline. I had someone who submitted right on the dot last time, and the computer marked them a day late, and there's all sorts of paperwork involved in that, you know. I mean, it's my job. I'm not complaining about that. I'm just saying, why make trouble for yourself? When I heard he said submit at least an hour before, that's great. And keep in mind, some people forget that there's Queensland time involved too, and there's a time difference. Western Australia is 3 hours difference with Melbourne. There's 1 hour difference with Queensland. You've got South Australia, etc., etc. So a couple hours in advance. But you're given plenty of time. This sort of stuff you should be able to do in a 2 hour. You should be able to do this in a 2 hour exam or a 3 hour exam. It's not to say that you can't take longer than that. Listen to what he says, because I'm beginning to forget some of the things he said, but they're really good. Tell your family, if you've got families around the place, just to leave you alone for the day. Know your stuff between now and then. Go through your stuff. It's always good to know your cases. Know your skeleton. That's what I've been saying to you every week. Know your skeleton, because that helps you with your instant recall and bring them up and speak about it. Don't overwrite, don't underwrite. I really can't think of he had a lot of good things. Take your time. Just do a question, walk away for half an hour, and come back and do the next one, and do the best as you can. For heaven's sake, it's a waste of time and money, a waste of time and marks to be late. If you've got a medical issue, get a doctor's certificate. But why do you need? Why do you need it? You know, just do it. You know, these are not. If you've been listening, you guys who have been here listening to me, I know you, because I know Jason, I know Daryl, and Michael and the other one. Although Jane's in the background, I know you people. You've been contributing. You guys will do well, because whenever I ask you a question, 90% of the time it comes up with the correct answer. It's the ones who haven't been doing their work will find this difficult. But that's not to say you guys should slacken off. You need to know how each. Well, the way I would do it is I would have one piece of paper with a summary of the 12 lectures, and underneath that I'll have 12 pieces of paper, one summary of each of them, and then I'd have my notes underneath that and summarize up, and be able to recall. We had to do that when we had closed books. We weren't allowed to take books in. It's better with you, but you still need to understand how it fits together. Okay? So be careful with your time. I'd start right at the very beginning. And if some sort of emergency occurs, at least you've still got plenty of time. As I said to you, the maximum it should take, you should be able to sit down in a 3-hour exam and do this. You know, I think you could do that in less than 3 hours. But take your time, write the questions, but just don't overdo it. And go to Anthony's, the last, say, 5 or 10 minutes of his lecture. He's got some good stuff there. That's all, and I'd just like to thank you all for coming in each week. I'm always of the opinion that it's easier to attend class than not attend and have to do the work afterwards. You know, that was always my philosophy. You know? So Daryl, it was lovely to meet you there, and Jason. Michael's got a test tonight, and Mary can't make it. And Jade, I know I can see just a black square, but Jade, wish you all the best, and that's it. You know. But I have the ones I've seen for quite some time now. I know you're subject to you doing the work what you should be doing and not doing something silly. I can imagine good marks from you. Okay. So,
could I just clarify 2 points?
Yep.
The word count, which I stuffed up on the assignment, I considered that 1,200 each question, but it was 1,200 overall, I believe.
Yeah.
This one, it's for the whole lot. Whatever the word count is, it's for the whole lot.
Yeah, let me write that down. I'll review it again tomorrow because I just can't remember. So assignment 5 word count. That's good. Yeah. So, and your second question?
The overall. I think it was on the assignment blurb there in your Moodle. It says it's around about the 2,000 mark. But obviously that's not going to be 2,000 each question. But I'm just making sure that's what we're looking at.
A good question. Leave that to me, and I'll look that up, and I can give a good summary of all that. And your second question?
Contracts B. Should I jump straight into that next semester? As long as I pass this and the stars align, and I keep doing it.
Well, my thoughts on that matter are very clear. You should do it because your mind is fresh.
Yeah.
Okay. Now, as apart from a lawyer and accountant, I'm also an educator. And in education school, we were taught that your memory fades extremely quickly. Now, yesterday and the day before, I had corporate training for senior executives in some of the stuff we're talking about tonight. I said to them, look, that within 24 hours, you're gonna remember. I've forgotten what we were taught in education school, but say 50%. A couple of days later, 40%. A week from now, 30%. 2 weeks from now, 10%. A year from now, 1%. So what I'm trying to say, if you wait another term, you're going to say, bloody hell, I wish I would have done it because I still had that stuff in my mind. Because the next term is only a couple of weeks off, isn't it? Or a month off.
Yeah, that's right. Yeah.
Just go straight into it.
Speaking of stars aligned, Daryl, I wanted to do that as well, and I don't think it's offered in semester 1 to ours. I think it's semester 2. So.
Okay.
Oh, okay.
We might have missed the boat there, buddy.
Well, what you do for both or 3 of you there, anyone else who's listening, keep good notes and put them in week by week. In my notes, I've got a ring binder with 12 tabs, and I keep each one there, and I have a summary. I have my my summary sheet with the thing on there, and then I could come back in a year's time and quickly read it through because that is the skeleton plus a little bit of flesh around it. And I've got the cases, and the cases are really straightforward. You just need to go to the book, just look at the case, or you can go to the textbook and or just go online. Cools and Baggett's case. Well, that's just you just got. There's always some lawyers written about something like that, but it's how it all fits together. And as a lawyer, you're not expected to know everything. So make sure that you understand how the skeleton works. And so there's an arm there, and there's bits and pieces in the arm, and then you know where to go and look it up. But if you don't know there's an arm there and underneath it, that's where you're in trouble. And that's where the people who are slack, who party right until a couple of days before the exam, that's where it's very difficult for them because they don't see the big picture. They just quickly pick up a book, and often they're lucky to pass. And indeed, I've met a lot of these people. They may pass and they beat themselves on the chest and say how great they were pass, but they haven't learned anything. They forget it very quickly. You guys have been here. It'll be more or less indelibly etched in your minds. Okay. Anything else?
I'll just let you know I've swapped all of your virtual chocolates for a glass of wine for when we're done.
Well, it's a pity you don't one of the real classes because I like giving chocolates out when someone comes up with some good discussion, you know, brings up a good legal point or an issue which is really quite good, you know, and another way of thinking it, and they deserve that, you know. We need to keep the class engaged, you know. So, Daryl, now you're from memory, you're a train driver, and now you're going into the law, correct? Is that right?
When I've gone far enough into it, yeah.
Yeah, that's good.
Yep.
And Jason, what about yourself?
I'm an electrician.
Yep.
But I'm going to steer very far away from that once I finish this degree and get into hopefully some sort of commerce law, maybe contracts.
Don't let me tell you what to do, but make sure you do a commerce or an MBA as well.
Yeah.
And you'll be a knockout. Because
that's part of my plan.
Sorry?
That is part of my plan to go down that avenue.
I'd suggest strongly, because I deal a lot with the construction industry, and you would be very, very desirable person to have on the team, either in a professional practice, either in a business practice giving business advice, a lawyer's firm in construction, or working for a construction company, because the thing is, you've seen how it works. A friend of mine, he was a project manager on a building site, and what he did is that he really enjoyed all this sort of stuff. He went to law school. Now he's a leading construction lawyer because he's been on the site. Now, if it was him and me side by side, and we were both the same age and both the same amount of years experience in the law, he would do far better than me because he's been on the site. Okay? And exactly what I'm trying to say with you. And Daryl, if you can somehow fit in what you know about mining and resources and stuff like that, it's silly to lose that. A friend of mine's a lawyer. He's a totally brilliant musician. He's written some symphonies and stuff like that. He doesn't use anything from his creative past at all. Not even, he doesn't, I thought he could have gone into copyright and stuff like that, intellectual property and the arts. He didn't. And he's practicing without the benefit of his prior life. So why lose the benefit of your prior life? So I'm saying, Daryl, if you can, I think Jason's got a more direct one because being an electrician, you know, and you just got to find out where you can fit in. So Jade, I'd like to help you too, but I can't see you nor especially hear from you, but try to use something like that. Now, when it comes to the law, look, I don't know what the percentages are now. When I went through, I'm just guessing, 80% went into the law, maybe 40% now go into the law because there's too many lawyers around, but they love you in commerce. You know, you work in procurement, you work in sales, you work in operations, and particularly with Jason and Daryl with their previous backgrounds. That's fantastic. And in fact, what you might want to do is not wait till near the end of your degrees, start schmoozing around and finding whether you can do a bit of holiday work with someone. You know? Daryl, you're still working?
Yes, yeah.
Yeah. What you do is talk to management and just say, would you mind if I do some managerial aspects? Then are you doing the law as well?
Some do, but I haven't put it down as a like for a company paid thing. That's what I'm doing off my own back. Yeah. Yeah,
but you should get the benefit of that because you should be now doing a bit of managerial work where you, and if you have the energy too, you can do an MBA because that would be really good to top things off. You know? Because I make this, as I said yesterday, the day before in Perth, I had a room full of senior executives, you know, and I see them, and sometimes they come up to me afterwards. Not this time, but sometimes they come up and they say, "Oh, look, I'm 40 years of age. I stuffed around. I never got to uni. I went to uni and I dropped out, and I got no career. What should I do?" And in your cases, you've done something proactive. You've gone to CQU. CQU can also provide you with a commerce degree or an MBA, or you go to another place, depending on what suits your needs best. But obviously, finish this one first. Take a break, because this stuff's not easy, It's good.
While we're on this topic, actually, would you recommend doing an honours degree in law?
Depends on where you see your future as. And on it, when I went through at Melbourne University, what we had is that you didn't have to do a longer period of time. You had to get higher marks. So I'm not quite sure what happens at CQ. Do you need to do an extra year, or you just get higher marks?
I think it's a combination of column A and column B. So I think you need to have high enough marks to go there, but I'm not sure how high those marks are.
Well, look, I'll just go, like I said I think it was to Daryl 20 minutes ago, on that 1% question, if you put another hour in, you're still going to get 1%. Now, if you, depending on what you want to do, if you want to go deeply into the law, well, honours degrees are very helpful. It might help you get a job. You might even work with a judge or something like that. But if you wanted to go around into more general commerce and stuff like that, the extra time you spend to do that extra study might be better used elsewhere to go to CQ and do a commerce degree or an MBA. An MBA is more impressive because the door opens and says, "Please sit down." All an MBA does is allows you to into the room. You've got to prove yourself afterwards, of course.
How about travelling in the direction of becoming a barrister?
You are?
I'm just asking. Would you highly recommend an honours in that respect?
Yeah. It's helpful, but I'd still do a variety of work because I was a forensic accountant for many years, where I appeared in court on some big cases, and a lot of the barristers are good at the law, but they don't understand how business works. I would still say if you can become a barrister, it's even better reason to get a broad background. Even better reason. Because particularly in a business case, and they can't understand the numbers, lawyers in general, I have to hold their hand to understand profit and loss and balance sheet and all that sort of stuff. And you'll be doing that in an MBA, both of you and the other ones, Jade, you can too. Depends on what you want with your career, But if you want to stop now, it's one thing. But if you want to go ahead, a broad career, it could be very helpful. And in fact, I've been reading up on law firms, and they're saying that they've got too many people who are just lawyers. They want to have people with wider qualifications. My own daughter, she was doing law commerce, and she said she didn't like the commerce part. I said, "Darling, you really should stick with the law, with the commerce." No. I'm just a dad. Who am I, And she dropped out. Oh, I went to the graduation, and when she was admitted to the bar, and I had my wig and gown on, I admitted her, and there was about 100 others. And I thought to myself, what does she have to offer anyone else? What has she got to offer anyone else? And it's important that you have something on offer. And so if you come out with a law degree and then you do something else, and CQ's got, they know you already, you just slide into something there, that'd be very helpful for you. So she was just lucky because I pushed her into a couple of holiday jobs in an insurance company and things like that, kicking and screaming, and then she now thanks me very much, because that was the only thing which got her the job. She's now in personal injuries and things like that, So,
I'm just shocked I'm shocked you're telling me your daughter wasn't listening to her dad. I'm amazed.
Well,
I got two of my own.
I got another couple around the place as well, No one listens to me. I'm just a dad and a husband, But at least the students listen, sort of,
Only when you keep giving them chocolates.
One day again, I hope we meet Jason, Jade, and Daryl. I'll meet you again on your papers, but there'll be no favouritism as you imagine. But what I've done is I've given you all a bit of a look at what needs to be done. And all the best. And if there's any issues, just email me through, and I hope one day to meet you again. Okay.
All right. Thanks very much.
All the best. All right. Catch you later. See ya.
See ya.
Bye bye.